Good morning, everybody. Happy Friday. And thank you for joining us today on a very important show today. Shouldn't even call it a show. This is important legal analysis that we have to do in order to hopefully bring justice and fairness in what's going on with Kelsey Fitzsimmons. As you know, we've been covering this case pretty extensively. As soon as I got wind of it, saw what happened, saw the wrong rulings, the errors, and it upset me because that's not what's supposed to happen in our criminal justice system. So to quickly catch you up before we pull up the relevant documents, what's been going on with Kelsey Fitzsimmons is that she was arrested and she was indicted on one charge of assault with a dangerous weapon. She was then detained, and after some bail hearings, was finally released on some very specific and restrictive conditions, part of which required her to blow into this scram device, which was very difficult for her because she was shot, and she had some broken ribs and some other injuries that she was recovering from. After all, she was in the hospital for 53 days, had multiple surgeries. One surgery she was not even able to have because of her ankle bracelet. So eventually she was let out, and Tim Bradle, on his own motion, which is an important part of this, which we're going to get to, filed a pretty simple boilerplate motion. Let's modify the release conditions to make it more doable for her. She was not in violation. There's no allegations that she was in violation. So he filed a motion, had a hearing with the court, and the judge, for some reason, got very upset and stormed off the bench and said, "We're just going to revoke her bond." And there was a motion for reconsideration that was filed that was denied. Then it was appealed to the single justice. That was denied, and now they appealed it to the full bench. That is where the Kelsey Fitzsimmons case is holding right now. I know yesterday there was a hearing on her probate matter in family court. Seems like that was really mostly about the venue issue. So before they got to any sort of merits of the motion to attach property and not allow Kelsey Fitzsimmons to sell her house to cover her legal expenses, before they even got to that, there's some issues with venue apparently. So they have to work out make sure they're in the right court, doing the right things before they actually start making substantive rulings. That's what seems to have happened yesterday in family court. So then yesterday, late in the day, they had this appeal that was filed, got my hands on it, and now we are going to be breaking down the appeal. Okay, so let's pull it up. And just to, as a little reminder, I think this is actually mentioned in the appeal itself. They're very limited in how much they can talk about in this appeal. They're limited to like 10 pages. And in appeal work, that's very limited. I know I've had appeals with, 30, 40 pages. So they're very limited because of the nature of the appeal. So they may leave things out that they wanted to get to but couldn't get to. Maybe they'll bring it up in oral argument. But let's first start, before we actually jump to the appeal, I think there's some important background information just in terms of the law. If you really want to understand what the arguments are here, which is why you come to this channel, if you really want to understand the arguments, then you have to really backtrack just a little bit to see what each judge did. So we'll start with the first judge, McCarthy. Then we'll move on to the single justice. Just I want to point out just one very brief thing in order to really make this appeal make sense to all of you. Okay, so let's start with the opinion from McCarthy. So here is the opinion from McCarthy. This is on the motion for reconsideration. Okay, so this is the motion for reconsideration where they're asking, hey, you got it wrong the first time, now get it right. And this is what she said in order to deny the motion for reconsideration. Okay, so here we go. Give me a minute here. By the way, good morning all in the chat. I see all your good morning wishes. I appreciate it. We're not going to go through all of them right now. If you have any questions, you can put them in the chat. Probably I'll get to them later if you can. Okay, so now take a look at this. So this is what the judge ruled. Now, there's a few problems with this order, as I've gone through a number of times. I have a lot of problems with the analysis that McCarthy ran through here. But like we've spoken about, there's two different parts of the statute. There's 58A and 58B. 58B is really what happened here. She really operated under 58B, but that was a big problem for her, because if she operates under 58B, it's automatically very clearly an error. So therefore, she's smart enough to figure that out, and therefore she tried to tie in 58A. 58B has to do with a violation. If there's a violation of your bond, then it can be revoked, and over here there's no violation. So she tried to tie it into 58A, which I have some serious problems, grave concerns with that. I think that's also an error. I'm not sure if that was brought up in the appeal. We'll see in a minute. But this is what, in order to understand really a big part of the appeal, you have to understand. And that is this. When she says here, ultimately, and I highlighted that so you can read along with me, ultimately, whether to do so or not is a matter of judicial discretion, and a reviewing court will disturb a judge's decision on a motion pursuant to Rule 13A5 only where there has been an abuse of discretion. Okay, now there are different standards of review. When you're asking another court, a higher court, an appeal court, to review a lower court's decision. So depending on what the issue is, that's going to depend on the standard of review. How should the higher court look at the decisions? Should they give any deference to the lower court judge's opinion? Should they do that, or should they look at the issue fresh? So that's the difference you have to keep in mind here, because that's a very integral part of this appeal. So here, McCarthy said, and she's kind of like hinting to the higher courts that, look, you can only reverse me on an abuse of discretion. Abuse of discretion is extremely high standard to say a judge abused his discretion. I'm actually in the middle of an appeal right now where a higher court judge, actually in my case, decided that the lower court judge, which in my opinion was 100% correct, abused his discretion. So the higher court, one of the higher courts, this one judge decided that my lower court judge abused his discretion. He laid out, by the way, a 13-page opinion on this matter, beautifully analyzed, citing to the appropriate statutes and the case law. But this higher judge says, no, he abused his discretion. So we appealed that, obviously, because it's such an incredibly high standard that you very often don't get that, to find that a judge abused their discretion. Now, in this case, I think even if we would use that standard, she still would have abused her discretion. But it's easier, obviously, to get away from that. No other judge wants to say a lower court judge abused the discretion. I still think there is, but still, it's easier to get away from that. So, but you see from here, what McCarthy is saying is that, no, look, I mean, you guys want to appeal this? You want to take this up? Okay, well, the higher court should understand that it's only going to be reversed on an abuse of discretion standard. Now, let's see what happened with the opinion of the single justice. It was a very short opinion here, as you remember, and there was really very, very little analysis done on the single justice opinion, which also was a little upsetting to me. And I think also the analysis was faulty on the single justice opinion. I'll tell you why in a moment. But first, look what he says here. This is the reviewing judge and the single justice. It says the following: and the judge's orders, this court concludes that the judge did not commit an error of law or otherwise abuse her discretion. So it's almost like the single justice is saying that I'm not only looking at an abuse of discretion, I also find that the judge did not commit an error of law. Why is that? Why did the single justice, before we even get to the appeal, why did the single justice feel that Judge McCarthy did not have any sort of errors of law? So the only thing that you can point to here is the footnote. This is the footnote that we spoke about. And this is where the judge, the single justice, found that, well, this is the appeal to the single justice was based on 58B, which is essentially what happened here. Okay, like this is just like, let's not pretend that this wasn't a revocation of a bail. This was. And that's what 58B was created for, right? To revoke bail. So therefore, in the first appeal to the single justice, they said, look, this is a revocation. Therefore, it should be analyzed under 58B. And that was a lot of the analysis in the first opinion. So what this single justice did is that, well, it wasn't 58B, it was 58A. So since it was 58A, we don't really have to consider all your arguments for 58B, And if you look at 58A, then the judge did not make any error of law to revoke the bail. Now, we spoke about this in our previous video. We don't have to rehash it all now, but there's also problems with that using 58A. Two main problems is that 58A, in my reading of it, only has to do with somebody who is already detained. And you're trying to get the person out. 58B has to be with a person who's already released. Like in this case, Kelsey was released. So I don't think 58A applies, and therefore I think it's an error of law. It's an error of law, number one, if you apply the wrong statute. Number two is if you misunderstand the statute. So, if you completely misunderstand the law or apply the wrong law, that is an error of law. But this is what the single justice opinion held. Said, look, it's not a 58B issue, as Judge McCarthy said, there's a 58A issue, and therefore we are not going. There's no error of law here. Essentially, that's what the single justice found. So now, and also they found that there's no abuse of discretion. But again, very, very little analysis in the single justice opinion. So now let's move on to the appeal to the full bench. So they are only limited with the pages here. They actually, as you can see, they kind of squeeze this in because I think officially it has to be double spaced, but seems like they have to squeeze in this. So take a look at this and let's get through it. In sum, there's a quote from a case, Brannigan, which is an important case, which actually I'm going to be talking about a little bit more as we go through the opinion, this Brannigan case. In sum, in our society, liberty is the norm. Remember, because what I've said was, and even if you want to analyze under 58A, what you have to do is you have to also apply the constitutional requirements. There's something very important here, due process. Now, at some point, this statute was challenged in general. I mean, 58B in general was challenged on constitutional grounds. It was found to be upheld. That's fine. If the general outline of the statute, but there are still certain constitutional requirements before you take someone's liberty away. They have to be followed, and we're going to see soon from Brannigan about that. But that's where liberty is. In sum, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. So think about, mass murders or, people who commit heinous crimes, people that are a flight risk. So carefully limited exception. Does Kelsey Fitzsimmons fall into a carefully limited exception that she has to be detained, has to be locked up and her liberty taken away? Although the federal constitution and the Massachusetts Declaration of Rights do not prohibit pretrial detention, right? There are certain times when you're allowed to detain someone. They permit it only in carefully circumcised circumstances and subject to quite demanding procedures. This traditional right to freedom before conviction permits the unhampered preparation of a defense and serves to prevent the infliction of punishment prior to conviction, right? If you're not convicted, you shouldn't be punished. And being locked up is much harder to prepare for a trial with your attorneys than when you're out on bond. Unless this right to bail before trial is preserved, the presumption of innocence secured only after centuries of struggle would lose its meaning. The practice of admission to bail, as it has evolved in Anglo-American law, is not a device for keeping persons in jail upon mere accusation until it is found convenient to give them a trial. On the contrary, the spirit of the procedure is to enable them to stay out of jail until a trial has found them guilty. Without this conditional privilege, even those wrongly accused are punished by a period of imprisonment while awaiting trial and are handicapped in consulting counsel, searching for evidence and witnesses, and preparing for a defense, right? So obviously it handicaps your ability to prepare a defense and present a defense when you're locked up. And the lawyers can't do it themselves. They need their clients' assistance. Running over to the jail all the time is not always exactly convenient. So now let's get through this. It's not that long. We'll get through it, and we'll talk about it as we break it down. Now comes a petitioner, Mrs. Kelsey Fitzsimmons, held without bail, invoking the foregoing principles, and hereby appeals the interlocutory decision of the single justice. She proceeds pursuant to Supreme Judicial Court Rule 2.2.221 and asserts that the single justice applied the incorrect abuse of discretion standard of review. Now, technically, you can argue that, we did see that the single justice said that they did not find, or he did not find, an error of law either, but this is an important part of this appeal, that you have to apply the correct standard. And if you apply the correct standard, then it's much more wide open for you to make a correct decision. The single justice declined to reach, under the proper de novo review standard, the merits of Ms. Fitzsimmons' case as a person deserving of a traditional release or on bail or recognizance. So de novo, that's the difference of de novo review and abuse of discretion review. De novo review is simply when the court looks at it completely fresh, taking a fresh perspective, not giving any deference to what the judge previously in the lower court ruled. So what they want to establish very strongly in this appeal is that the proper review here, especially when you're dealing with error of law, is a de novo review. And if you're trying to apply abuse of discretion when it comes to error of law, that's incorrect. So that is what they feel happened here at the single justice level, that even though they said, or the single justice said, I shouldn't say they, the single justice said, yeah, we don't find any errors of law, but that's because you were using the abuse of discretion standard instead of the de novo review standard. The interlocutory order of the single justice was thus based on an error of law and abuse of discretion and must be vacated by the full bench, which should also decide the bail issue and release of Ms. Fitzsimmons. Petitioner was before the Superior Court on only one count of assault by means of a dangerous weapon, a 5-year felony at the very bottom of the threshold for Superior Court jurisdiction. She is eligible under the proposed sentencing guidelines for a probationary sentence, meaning that she's eligible for that, even if she's found guilty of this, that she'd be eligible for a probationary sentence, not being locked up, no jail time. She is a police officer and former corrections officer. At the time of her incarceration, Ms. Fitzsimmons was at liberty and on release under 58A terms. However, the Superior Court layered many excessive demands on petitioner. She was placed on a GPS bracelet house arrest with almost complete lockdown, accepting medical and lawyer visits, but only with 48 hours notice, required to abstain from alcohol use, and required to blow into an alcohol sensing device referred to as a scram monitor, stay away from the responding officer who shot her in the chest, and stay away no contact order from her own baby, regardless of the probate and family court orders. It became quickly clear after only a day that petitioner could not constantly blow into the device, right? This is just a brief history of what happened here. She was not able to blow into the device without severe pain and dizziness. And she returned to Superior Court in good faith on her own motion. On her own motion is important here because that is what implicates the due process problem here. There's a tremendous due process issue that I see here because, number one, is that this was not a motion to revoke her bail. She wasn't on notice that this may revoke her bail, and therefore there's some serious due process problems here. This was on her own motion, seeking assistance and a reasonable accommodation, all with the support of her probation officer. You'll remember at that hearing, if you listen to it, that the probation officer was completely on her side, saying that he's seen this, he's seen that she has problems blowing into the scram device. It gives her pain, it makes her dizzy, and he was on her side. So usually when the probation officer is on your side, that's a very good sign, right? They're all on the same page. Instead, without a request for surrender from either the Commonwealth or probation, the court revoked the release plan and without notice, again, a very important part, without notice, that means that there's a due process violation, put Ms. Fitzsimmons into custody for 180 days. The court then walked off the bench, ignoring counsel's argument for reasonable accommodations. Alternative testing means urine testing, and the required least restrictive terms of release under 58A. Now, least restrictive terms is an important legal term here because that also implicates the due process requirement. So now Rule 2.21 is just talking about when you're allowed to go to 2.21, when you're allowed to seek a full bench appeal. We don't have to really get into here too much. But let's just quickly go through it because it's not that long anyway. Supreme Judicial Court Rule 221 allows a full bench appeal of unreported interlocutory orders by a single justice, which is what happened here. The rule limits briefing to 10 pages. So understand that they're limited to 10 pages here. So you may not see all of my beautiful, elaborate arguments that I said could have been made because they're still very limited. And confines the new pleading to addressing reasons why review of the trial court's decision cannot be adequately obtained on appeal from a final adverse judgment in the trial court or by other available means. Here, Ms. Fitzsimmons has no ability to obtain alternative review of the underlying trial court's bail decision. Left undisturbed by the single justice, finding her to be a danger, revoking her release without notice, and holding her without bail. I mean, we can't wait on this issue. It's not an issue we can just wait on and appeal after there's either a conviction or an acquittal. That's not something we can do in this case because she's in jail right now. This issue needs to be addressed right now. The nature of a bail decision incarcerating a defendant pretrial constitutes a real-time intrusion on her liberty interest that cannot be addressed or remedied in the future in a direct appeal. That's exactly what I just said. It is axiomatic that bail decisions must be speedy if they are to be effective. And the bail review framework etched into the Commonwealth, into common law by this court in the following cases and the progeny, mandate review and a de novo decision. The full court's review of a decision incarcerating the defendant while awaiting trial will be focused on whether the detention decision was truly rendered only in carefully circumscribed circumstances and subject to quite demanding procedures. Well, is that what happened here? Was this carefully circumscribed circumstances, say that 3 times fast, and subject to quite demanding procedures? Errors of law in connection with review will be remedied by the court's own independent determination of the law and its application to the case at hand without deference. Okay, errors of law, you have to analyze not under abuse of discretion, which is what the single justice did here. At least that's what the allegations are. And again, the opinion is so small and short. There's no standard of review even there. It's such a bare bones opinion of the single justice. So there's no deference that's given to the judge below. The erroneous intrusion on petitioner's liberty interest cannot be restored at a later date through the appeal of a final adverse judgment or by any other available means. Meaning we have to do this now. That's basically what this is saying. This is what this rule was created for. This is why you're able to go to the full bench, because we need a decision on this now so she can get out now. We can't wait on this issue. If this is like some sort of ruling, adverse ruling to a motion and limine or about evidence, okay, you can make that appeal later. Not in this case. Not when someone's sitting in jail. And now they ask for an in-person hearing request. They also ask for an expedited hearing request so we can get this done quickly. And then the request for relief. So that's just, what we all know. She should be released, etc., with more reasonable restrictions. Okay. Now, just to add insult to injury here, this is just a nice little footnote here, that undersigned counsel proffers that Ms. Fitzsimmons had to cancel what would have been her 5th surgery when the trial court refused to allow her to have her bracelet potentially cut off for the operation. You all remember that she was not able to have the surgery because the judge refused to allow her to have the bracelet removed. She cited because you didn't submit any medical evidence saying that it has to be removed. Maybe they can do surgery with the bracelet on. Okay, regardless, that was the ruling, and that's why she was not able to have the surgery. Okay, standard of review. And this is an important part of this appeal. The petitioner requests that the full bench review and decide the issue set forth before the trial court and the single justice. Full court has jurisdiction to review on exceptions, report, or appeal questions of law arising in a bail determination by a single justice under Section 58. This court further sets forth the framework for its review of a single justice bail determination in that case as follows. So this is the framework. When a party appeals from an adverse judgment by the single justice, we review the single justice order for clear error of law or abuse of discretion. We must also consider the propriety of the Superior Court judge's underlying bail order. In reviewing both the single justice judgment and the bail judge's order, we must consider the legal rights at issue and independently determine and apply the law without deference to their respective legal rulings. We do not use, again, and this is going to be hammered over and over again, that we do not use the abuse of discretion standard. Now listen to this. A lot of people have been asking me this question, and my answer to this question was usually not. But here is where they're asking, as part of the appeal, that the full bench actually listen to the hearing. Everyone's been asking me, are they going to be able to listen to the hearing? Is the full bench going to be able to listen to the hearing and hear the tone of the judge and what exactly happened? Because when you hear that, all these alarm bells start ringing in your head that there's something wrong with this judge. So, or definitely the way that she handled that hearing. So Ms. Fitzsimmons respectfully submits that it is imperative for this court to listen to the recording of the trial court bail hearing, which recording is Exhibit 1 of single justice petition. The single justice apparently only reviewed the transcript later provided by the Commonwealth and was not able to appreciate the egregious treatment of the defense and the probation department, which is made clear by listening to the hearing, culminating in the judge departing the bench, storming off the bench, while defense counsel was mid-argument. No reasonable listener can reach the conclusion that the court approached the matter impartially. It should read impartially there, a little typo there. Okay, so if you listen to it, it makes things a lot worse. But generally speaking, I would think that most of the time they do not listen. They just read the transcript. But here they're saying that having a specific request, please just listen to that hearing. So they may listen to it in this case. Okay, so this is where, okay, let's just continue. Moreover, a demand for excessive bail would violate 26 is the Declaration of Rights of the Constitution of Massachusetts. Compare the 8th Amendment to the Constitution of the United States, which has been assumed to have application to the states. All right, trial court ruling. What was the trial court ruling? Here, as amply set forth in the petitioner's single justice brief, which is incorporated, by the way, so they don't have to rehash everything that was in the single justice brief, the trial court's decision was infected with errors of law, misinterpretations of the record, and unexplained hostility towards the defense team and the probation officer who was testifying in favor of the defense's position. That's undoubtedly true if you listen to the hearing. The defendant is not dangerous. She is a dedicated and conscientious police officer, and she adamantly denies that she pointed a gun at the responding officer. She has no alcohol problem, and the incident has absolutely nothing to do with alcohol. There is no ongoing, which it would be important to know when you're deciding what type of restrictions to put on for bail. You know, if the crime has nothing to do with alcohol, then there's no reason to impose alcohol restrictions or testing. There is no ongoing future potential danger to the responding officer who almost killed her that could justify a finding by clear and convincing evidence, and no condition of release are available. The officer saw a gun and fired, and by claiming petitioner pointed the gun at him, all his problems go away. So again, this is a he said, she said type of situation where she's saying, I never pointed the gun at him. He's saying you did. Well, for him, he has a very strong interest in making that claim because then all his problems go away. But still, guess what? Kelsey Fitzsimmons has a presumption of innocence. Ms. Fitzsimmons is only a danger to herself, and using deadly force on someone who only exhibits a danger to themselves is unlawful in the Commonwealth, right? A police officer cannot use deadly force against a person who poses only a danger to themselves. This court is empowered to apply its collective trial court experience and knowledge to consider the legal rights at issue and independently determine and apply the law without deference to the respective legal rulings. In using such collective experience, there is no reasonable scenario in which Ms. Fitzsimmons should be held or be subject to the panoply of harsh conditions imposed by the trial court. No justice on the instant panel would impose such conditions and then incarcerate petitioner as a result of a serious health issue, making compliance torturous and painful. The single justice ruling was also based on an error of law. As set forth above, the justice was required to review the matter de novo and decide the bail issue. Instead, the single justice only examined the trial court's actions under the much narrower abuse of discretion standard, and in any event, did not appear to examine the propriety of the bail issue itself at all. Right? Again, there was a bare bones opinion there. So it's really very, very difficult to understand what the thinking was behind the single justice. I mean, there was just that one little footnote, and then it didn't even say which standard it's using. Yes, it did say error of law, but it didn't say what standard it used. The single justice appeared to be solely focused on whether 58A applied over Section 58B as the proper interpretation of what transpired in the trial court. Right? That's exactly what happened. That was footnote 1. That was the entire analysis. The justice also gave full abuse of discretion deference to the trial court's 58A finding, the harsh conditions, the surprise incarceration, and the completely unnecessary adherence to the at-home scram breath test. The decision also ignored the application of the American with Disabilities Act and the opinions of 3 experts, a psychiatrist, psychologist, and LICSW, all opining that petitioner is not a danger. The reviewing court also ignored readily available reasonable accommodations such as the urine testing option, or categorizing a urine test at a facility to be a medical visit fitting under her rubric. So, yes, you could allow her to leave her house to just go get tested, just like you would allow her to leave for medical leave. Under the proper standard of de novo review, a reasonable judge would perceive the necessity to comply with the American with Disabilities Act, as well as the 58A requirement to impose the least restrictive alternatives and allow Ms. Fitzsimmons to travel to a nearby urine testing facility. AverHealth Industries, a Commonwealth vendor that routinely provides this testing service just 10 minutes from the petitioner's residence. Court could have done that. Would have been least restrictive. Would have been less restrictive than locking her up. Probation also utilizes in-home visitation from Commonwealth vendors who can come to the house and administer tests that are sent to the probation officer. So even if the court would have decided, Kelsey Fitzsimmons is just way too much of a danger. I mean, look at her criminal record. It's just as long as anything. And therefore, she's just a danger to the community. Well, if that's true, that you're just terrified that this 5'3", 110-pound woman who was just shot and can barely breathe is a danger to the community, or poor Officer Noonan, well then, and therefore you can't allow her to leave her house even for 10 minutes, well then there's also in-home visitation from Commonwealth vendors who would be happy to come to her home and test her there. A reasonable bail determination would also not include complete lockdown, GPS bracelet, and 48 hours notice for medical and legal visits only. The incident before the court had nothing to do with alcohol use or abuse and does not justify the rigid demand for only a certain type of alcohol testing over another type that can serve as a less restrictive alternative and reasonable accommodations under the ADA. The court should have further inquired of a probation as to the many other options available and not simply abandoned an examination of the least restrictive alternatives and locked her up. Therefore, for the conclusion, for the foregoing reasons and the reasons set forth in the petition of single justice brief and exhibits, which are all incorporated, the court should vacate the order of dangerousness, grant the petitioner release on personal recognizance with a stay-away order, and remand the matter back to the Essex Superior Court before a different judge for further proceedings in the case or such other relief as requested above. Here we go, and that it is signed. So that is the appeal to the full bench. Okay, so laying out very clearly, if you analyze this under the correct standard, which is the de novo review, then you would come to a very different conclusion than the single justice did. Okay, and again, arguing here that the single justice, first of all, didn't identify which standard he is using. He just said there is no error of law and there's no abuse of discretion. Well, how did you analyze the error of law? So, and the analysis was, lacking is like generous because it's just a little footnote, which says, yeah, she's talking about 58A, not 58B. That doesn't do it because there's certain constitutional implications here. And I just want to show you what I mean because I've spoken about this before, but it bears repeating. Okay, so Brangen was the case that they cited all the way in the beginning. That was the first opening of this appeal. This is what this quote is from. Brangen. Important case. Very important case. So let's take a look at Brangen for a second. So we got to go up a little bit. It's a long opinion. We're not going to make you read the entire thing, but look at this because some people will be saying, well, who says the due process is involved here? Well, this case does. Brangen. And you take a look, due process requirements. We begin by reviewing basic constitutional due process principles and our previous decisions applying these principles to pretrial detention. So yes, talking about the 14th Amendment, which is due process, right? Fundamental right to liberty and freedom from physical restraint that cannot be curtailed without due process of law. So now take a look at this. And this is something that also was, I thought, very lacking, which is why it's I believe a constitutional violation here by the first judge. Requiring a particularized statement as to why no less restrictive conditions will suffice to assure the defendant's presence at future court proceedings is appropriate in light of the applicable standard of substantive due process. There's two parts: procedural due process, substantive due process. So as part of substantive due process, the court is required, and what the court is saying in this decision in Brangen, which would apply, it's a good case in Massachusetts, is that there has to be a particularized statement as to why no less restrictive conditions will suffice. That the procedure be narrowly tailored to the state's legitimate and compelling interest in assuring the defendant's presence at trial. So basically what I've been saying this entire time is that, number one, is that you can't ignore the Constitution. You just can't ignore the Constitution. And part of the Constitution is the 14th Amendment, which requires due process when you want to take away someone's liberty. And if you do run through that analysis, if a judge on her own, let's say you would argue that Judge McCarthy decided on her own, well, that there is due process here, and this is the only way, this is the least restrictive measure possible, then what she's required to do is write an opinion where she particularizes why all other restrictive means are not enough, and that the least restrictive means in this case is locking her up. That's what she'd be required to do. Did she run through that analysis? So she just said, well, I don't think she's going to comply with the conditions, and therefore we're locking her up. There has to be very specific explanation, because anytime you're going to take away someone's liberty, then you have to run through this analysis. Because anytime that are you taking away someone's constitutional rights, then you have to be much more careful than just writing off an opinion saying, yeah, I don't think she's going to comply, so therefore we're revoking her bond, revoking her bail. So I think a very strong appeal, and if this full bench actually takes everything into consideration here, number one, using the de novo review, they should get there using the de novo review that this was a clear error of law. Okay, number one, even the fact that she's using the wrong statute here, 58A, and I have some issues with that, which I've discussed in my previous videos. You can also make the argument, by the way, that 58A conflicts with 58B. And you may have two statutes that conflict with each other. Because 58B says you can only revoke someone's bond if there's a violation. If you want to say, well, no, 58A says I can always revoke someone's bond. Well, then what's 58B for? If you can always do it, then what do you need 58B for? Did they write that statute because they were bored one day and they just decided to write something? So is there a conflict in the statute? I mean, if you want to apply 58, now I think it's completely different because I think 58A has to do with somebody who is already incarcerated, someone who's already detained, who's been arrested. You want to get the person out. That's where 58A applies. Once the person's out, you move on. You move on to 58B. So number one, I do believe that there's an abuse of discretion, but it's harder for a judge or even the Supreme Court in this case to rule that a lower court judge abuses discretion. Nobody wants to hear that. But if they, even beyond the abuse of discretion, once they get to the error of law, which requires a de novo review, well then they can also get to the same way. So if you have any questions about this, I'll take a look for a moment in the chat, see if there's any questions that we can address. But that's going to be it. I mean, that is it for the appeal. I think that there's a motion that's also going to be coming for the expedited hearing. So we'll see more about that as it comes up. But in the meantime, this is what we have so far that was filed. So let me see what's here. Just going through the chat, see if I can find any questions here. And if there's not, we can just call it a day for today. We can move on with the rest of our day. And Becky kind of says the obvious here. She's being treated like someone with multiple past violent crimes, not her current status. I mean, something that you're supposed to take into consideration is a person's criminal history. What type of criminal history do they have before you can let them out on bond? I told you, the most laughable part about this is that they're saying that she's a danger to the community or the danger to Officer Noonan, who shot her. And that's the most laughable part here. All right. Okay, well, looks like it's been pretty clear. I don't see any. Here's a question here. Okay, before I leave, Brother Counsel, can Justin really get the sale funds taken away from Kelsey and keep for himself? Well, the way that I mean, it's again, a probate court and family court is not my thing. I don't know all the way that works, but it would seem to me from the little bit that I've researched on this, and again, it's not my area, but yeah, I mean, if you look about it, if you think about it, away from everything going on with Kelsey Fitzsimmons, all the drama going on with Kelsey Fitzsimmons, you just look at it as you have two people who one person owes custody payments or is required to make custody payments. Think about it. Let's just flip some roles for a moment. Let's say you have a father who's required to make custody payments, and the father doesn't have a job, and the father has no way of making money, and the father has an asset, a house, and the mother of the child wants custody payments. So you would understand in that case, well, then, yeah, maybe they could attach any custody payments to the house and the proceeds of any sale of the house. So it would seem to me that it makes sense, taking everything away, again, assuming that everything is legit there and, Kelsey's not being railroaded in probate court or family court. And, she's required to make the custody payments and she doesn't have custody of the children, whatever it is. I'm sure that's all going to be fleshed out. But in a vacuum, just looking at it as one person owing another person custody payments and not having a way to pay it, it would make sense to me that they can take the proceeds from the house. They can attach real property. But again, it's not my area, really. Here's a question from Rebecca. Did the officer say he felt threatened? I don't think so. Not that maybe he did. Not that I heard of. I mean, that would be like, Buchanan and Proctor saying that they felt intimidated by Turtle Boy. It would be as laughable as that. What about the prosecutor not objecting at the time or saying that they take issue with some other resources other than Scram? That definitely helps, as they mentioned in the appeal. The fact that the prosecutor did not object and was being very supportive of Kelsey is definitely helpful, I think. And now there's a question. I'm filing on the wrong court. Will the grandparents have to refile for the grandparents' rights? Okay, again, if venue is off, then everything has to be filed in the proper court. So, yeah, I mean, that's the way I would imagine it works. If you're in the wrong court, then everything that you filed in that court, and then the case gets moved to a different court, you got to file everything again in the new court. Shouldn't be too difficult. Magan says no custody payments have been ordered. Okay, well, if there's no custody payments, then I'm not sure how he can, if there's no order for her to pay custody, so then I'm not sure how he can attach the house, But again, family and probate is out of my league. That's not what I do. People are saying, Chloe, that Justin doesn't have custody. Okay, so I'm not sure who has. I mean, if he doesn't have custody, who does? Who does it? Because she's in jail right now. So I don't know who has custody. I'm not completely familiar with who, the custody battle there. I thought that she did not have custody. I mean, I think from the papers that they filed, it said that he was granted custody. But I'm not intimately familiar with all of what's going on in the family court. Lucy Fair, I came in late, but might have missed this. What do you mean by this is a due process violation? Just again, very briefly, like I've said, is that there was no notice here. That's number one. There's no notice for what was going to happen in court. You want to take away someone's liberty, you have to give them notice. We are going to be taking away your liberty. Be on notice. Be able to come and argue that. Give them opportunity to present evidence or facts or witnesses why their liberty should not be taken away. That's part of due process. You have to have the ability to defend yourself. So that didn't happen here. And then also in the way that it was handled, the way that her due process was taken away, even if you get beyond the procedural defects, then there's also substantive process that was not done here. There was no clear opinion laying out all the reasons why this is the least restrictive means available. Magan says, again, no ordered payments. Okay, so if there was no ordered payments, I'm not sure how he can attach the house. But again, family law is out of my realm. Big Old Daddy says Justin has temporary custody. Okay, so again, I'm not 100% familiar with that. Okay. All right. So I think we kind of got through my thoughts about this, and there may be some additional filings here, and we will continue to follow this case because it's an important one, and hopefully the right decision will be made by the full bench, and Kelsey will get out, and then they can move on to actually litigate the case and see whether there's merits into the prosecution or not. Again, like I've said, if this is just a he says, she says, I'm not sure how they're going to prove their case, because you got to prove beyond a reasonable doubt. He says one thing, she says the other thing. It's going to be hard to prove beyond a reasonable doubt that she actually was pointing the gun. But who knows? Maybe they have some more evidence. Maybe they'll offer her a sweetheart deal. Who knows? We'll see as we continue to follow the case. But the first issue here is to make sure that her constitutional rights are being protected, which right now I don't believe they are. And that's why this appeal should be heard. It should be expedited. and they should get a ruling out on this, hopefully ASAP. Okay. All right. Well, thank you everybody for joining today. And we'll see you at the next video. And before you leave, just hit that subscribe button, hit the like button, and we'll see you next time. Have a great day and a great weekend. We'll let you know if we have anything cooking on Sunday. I have some ideas, so just keep your eyes and ears open for that. See you all later.